Hi there, I'm Darren Cope, owner of Cope & Co. We're a specialist letting agent based in Derby. Now, the new Renters' Rights Bill includes sweeping reforms that are going to change the private rental sector forever for both landlords and agents. Now, this is the fourth in my series of videos in which I look at different aspects of the Renters' Rights Bill, what it means for landlords and what, as an agent, we can possibly help landlords to negotiate the changes that are on the way. So, big one. How do you get your property back if the tenant is in constant arrears? Now, in the bill, there is a major update for the grounds for possession regarding arrears. So rules are going to be tightened to protect tenants who fall into arrears. And they're going to do this by increasing the mandatory threshold for eviction from 2 months to 3 months. And they're also going to extend the notice period to inform a tenant that proceedings are going to start from 2 weeks to 4 weeks. Now, in English, this means that the tenant needs to be in 3 months of arrears before you can act. Excuse me. And then you have to wait another 4 weeks before repossession proceedings can even start. So these new protocols for repossession will obviously impact a landlord's ability to address non-payment of rent quickly. 3 months arrears plus 4 weeks notice, it's effectively 4 months of arrears before any proceedings can actually begin. Now, there are actually two grounds for rent arrears that can be used for an eviction in the Renters' Rights Bill under Section 8, and it's important to distinguish between the two. So ground 8 is a mandatory ground for possession in a Section 8, and this can be used when a tenant is in repeated rent arrears. It's the one I've just sort of mentioned. Now, for this to apply, the tenant must be in arrears of at least 3 months at the time the notice is served and at the time of the hearing. Ground 8 does not apply if the arrears are to do with non-payment of universal credit and late payment of benefits. In this case, the landlord will have no recourse. Ground 10 is a discretionary ground for possession that allows a landlord to seek possession of a property if the tenant is in rent arrears of any amount. Again, for this to apply, the tenant must be in arrears at the time of the notice and at the time of the hearing. Now, that sounds a lot easier. However, remember, if a mandatory ground is proven, possession will be awarded. If a discretionary ground is proven, the court will still have discretion based upon the individual case whether to grant possession or not. So the government's intention with these new longer notice periods are to give tenants greater security and flexibility in challenging or addressing financial difficulties, but obviously from a landlord's point of view, they delay an ability to regain possession. A robust rent guarantee policy has never been more important for landlords to have in place. It will be an absolute must when this bill becomes law. Realistically, these procedural changes extend the timeline for possession. It's undoubtedly going to be lengthened. Landlords may face months to over a year even before they can regain control of the property. Court backlogs combined with procedural requirements for evidence in arrears, adherence to all compliance steps contribute to a potentially lengthy and costly repossession process. Now, fortunately, a really robust rent guarantee policy will have legal cost cover. Now, ours has £100,000 worth of legal cost cover. Again, this is going to be vital to protect against lengthy and costly repossessions. The shift emphasises the importance of early, proactive tenant engagement when arrears are at a minimum, at a very early stage, to try and nip it in the bud effectively, as well as the requirement for precise record keeping to avoid extended financial disruptions due to non-payment for a landlord. Now, it's clear that these grounds for possession regarding arrears have been strengthened enormously on the side of the tenant. As I've said before, understand the notice periods and timescales, understand what they mean, amass as much evidence as you can to support your claim, and be very organised and meticulous in your record keeping and audit trails. Remember, we can do all that for you. That's what we're here for. And also deciding which of the arrears grounds to use, if that's the way it's going to go, is also a very important decision, mandatory versus discretionary, etc. Now, finally, we have created at Cope & Co a new service which we hope will help landlords navigate the impact of the Renters' Rights Bill. We've effectively bundled all of our lettings and property management services together in one simple monthly payment, which we hope will help keep cash flow consistent and just make it just far more easy to understand what's going on. To find out more, please watch the final video in the series on our unique Let Simple service. As I've said many times, we're here to support you every step of the way. So if you want to contact us on any aspect of the Renters' Rights Bill or on any aspect of residential lettings at all, then please don't hesitate to contact us. Contact details will be somewhere on this video. This video and all the other Renters' Rights Bill videos can be accessed at rentersrightsbill.com. Thanks again for watching. I really do hope that you found the information useful moving forward.